Plaintiff Amalgamated Amalgamations Incorporated is suing defendant Guns R Us Incorporated to enforce a settlement agreement that arose out of a breach of contract claim involving the procurement of advanced weapons for a local hunting club. The defense is that no agreement was reached. To prove the agreement, the plaintiff seeks to introduce at trial a smartphone screenshot of a text message, purportedly from defendant's attorney to plaintiff's attorney stating acceptance of plaintiff's settlement offer. To do this, plaintiff's attorney takes the stand under direct examination by his second chair and testifies about the negotiations that led to the purported agreement.
Counsel for the plaintiff, you may call your next witness.
Would you please introduce yourself to our jury?
Of course. I'm Hugh G. Frickencrook, senior partner at the Frickencrook Law Firm, where our slogan is, nobody gets it done like a Frickencrook.
Mr. Frickencrook, in late September of 2013, were you involved in certain settlement negotiations with Amalgamated Amalgamations Incorporated in their dispute with Guns R Us?
Yes.
And who were you primarily negotiating with?
The attorney for Guns, Bob Big Bad Wolf, the dumb-looking guy sitting at defense counsel table with the ill-fitting suit.
How long did negotiations last?
From sometime in September 2013 to early November 2013.
How were these negotiations conducted?
Almost exclusively by text messaging. I've seen Mr. Wolf only a few times, mostly in this courtroom, the last time being some 16 months ago when he was trying to get sanctions against me in this case. In September 2013, he called me at my office and told me he wanted to settle this case. Later that day, he sent me an email proposal for settling the case. I sent him an email back telling him that Hugh G. Frickencrook was too busy to deal with email, that he should just text me his proposal. I gave him my personal cell phone number, and we started communicating back and forth by text message on my smartphone.
How do you know that it was Mr. Wolf who called you in September 2013, and that it was Mr. Wolf who was texting you?
The caller ID on my phone told me that the call was coming from his law firm, the Wolfpack Law Group. The voice of the guy on the phone sounded sort of like the voice of the guy that was at the hearing saying that he was Bob Wolf. My secretary screens all my calls, and I can assure you that no puny associate would ever get a call through directly to Hugh G. Frickencrook.
How many text messages went back and forth between the two of you before negotiations ended?
I don't know. There were a lot, maybe more than a dozen from each side.
How did you know that you were texting with Mr. Wolf?
Well, each text had a picture of his avatar. It's a howling wolf. It's the same thing that you see on his billboards up and down US 19.
Did you retain those text messages or keep a copy?
I did at first, but they're gone now. I reset my phone back to factory settings. I got a call from the Justice Department a few weeks ago about wanting to come see me at my office, so I don't have those pictures anymore.
Before you deleted them, had you discovered copies to the defense?
I didn't make copies, but I sent the defense a letter saying they could come to my office anytime they wanted, take a look at the text for themselves, but they never did.
Were you able to retain any record of the negotiation?
Yes, I made a screen grab of the last text that Wolf sent me accepting our settlement offer.
What is a screen grab?
A screen grab is the same thing as a screenshot. If you take your smartphone and you push these two buttons at the same time, you're going to get a picture of whatever's on the screen at that moment. When Wolf sent me a text accepting our offer, I made a screen grab of it and then sent it to my email account so that we'd have a record of the acceptance. Then I had one of my associates at the law firm print it for use as an exhibit here in court today.
What was your final offer?
On Monday, November 18th, 2013, I told him that I would settle this suit for $12 million in compensatory damages, $750,000 in attorney's fees, and $52,000 in cost. I told him in consideration we would voluntarily dismiss the lawsuit, and I gave him till 5 o'clock on Friday to accept that offer.
And what did the text from Wolf say?
I don't remember exactly, but he did accept my terms.
Would it refresh your recollection to view a copy of that screen grab?
Sure.
Your Honor, may I approach the witness?
You may.
I'm showing you what has been marked as Plaintiff's Exhibit Number 1. Do you know what this is?
Yes, this is the screen grab that I took. Right here from Mr. Wolf. Client Guns accepts offer of $11.18, $12 million compensatory, $750,000 attorney's fees, $52,000 in cost. You voluntarily dismiss. Please send signed written agreements to me as soon as possible so I can sign.
Is the screen grab you're holding a true and correct copy of the acceptance text that you have just testified about?
Objection! Buddy, you're going to be eating those words when I get you for cross-examination.
Overruled. Ma'am, you may continue.
Your Honor, at this time we move Plaintiff's Exhibit Number 1 into evidence as proof that defendant accepted plaintiff's offer of settlement and created a binding agreement.
Objection! Lack of predicate. That document isn't even properly authenticated. And even if it was authenticated, its content is inadmissible hearsay. And on top of that, it violates the best evidence rule. I mean, what kind of crap is going on in here? I mean, only a friggin' crook would try some scam like that in a court of law. I mean, just buddy, just wait till I get through with you on cross-examination.
Order. Order in the court. Counsel, approach the bench now.